What's good, fam bam? Thank you for joining your brother Koo. Thank you to all those who are supporting the page. So, at the request of one of our members, I'm finally coming out with this intricate video on trust law. So, first of all, peace to everyone. Hope you guys are all right. Hope everyone's doing well. Sorry for the late, for so much time going in between classes. I'm doing a lot of different things in between, especially in reference to our land. So I've been a little bit busy, all right, but I'm doing my best to make time to make sure I'm consistent with classes that'll help you guys. And like I said, it's nothing to just hop in the comments, and if there's a particular subject that you are needing clarification on, or maybe a thought coming into your mind, feel free to leave a message in the chat. You know what I'm saying? And then we'll go from there. So we're going to cover trust today. Okay, I hope you're seeing what I got pulled up here. We're going to, let me see if I can make this bigger first of all. There we go. That's better. Okay. So I have different things lined up, okay, as far as showing you how this thing is going to work. So first of all, let's just break it down. And right now we're dealing with American trust law, okay? American trust law. So with that being said, the United States trust law is the body of law that regulates the legal instrument for holding wealth known as trust. All right. So once again, the United States trust law is the body of law that regulates the legal instrument for holding wealth known as a trust. Okay? And so here, if I click trust, well, I didn't have to do all that. I could have just done this here. Boom. A trust is a legal relationship in which the owner of property gives it to another person or entity. I want y'all to hold that portion right there in your mind, okay? A legal relationship in which the owner of property gives it to another person or entity. Person or entity. Keep that in your mind, okay? Person or entity. Who must manage and use the property solely for the benefit of another designated person. In the English common law, the party who entrusts the property is known as the settlor. Let me go there. Known as the settlor. Where am I at? Settlor. Okay? In trust law, a settlor is a person who settles their property for the benefit of the beneficiary. In some legal systems, a settlor is also referred to as a trustor, or occasionally a grantor or donor. Where the trust is a testamentary trust, the settlor is usually referred to as the testator. Okay? So all that just means the person that creates it. Okay? So the party to whom it is entrusted is known as the trustee. The party for whose benefit the property is entrusted is known as the beneficiary. Okay? And a beneficiary in the broadest sense is a natural person or other legal entity. So understand that a trustee can be a person or entity, and a beneficiary can be let me not say person or entity, because we both know they mean the same thing. So for a trustee can be a natural person or an entity. And for a trustee's role, the beneficiary's role, they can be a natural person or an entity. So I said keep that in mind, okay? Because you can play either way. It's up to your imagination. So the trustee is the legal owner of the assets held in trust on behalf of the trust and its beneficiaries. Okay? The trustee is the legal owner. The trustee is the legal owner. The beneficiaries are equitable owners of the trust property. I'm going to just leave it at that. Let's move on to the next phase. Oh, I think I just read this. A little redundant. Get that out of here then. Cool. Okay. Now, since normally when I'm conducting commerce here, I'm normally conducting commerce with Washington State. Okay? So, with that being said, I decided to go and pull up RCW, statutories from Washington State Legislature in reference to trust. Okay? Because I don't just want to go off of Wikipedia and then, I like to give you valid things, but I want you to show that there's a pattern starting from Wikipedia, and then I'm going to get into the real substantial documentation, right? Okay, so here we go. Let's see if I can make this bigger for y'all. Okay. Hopefully I can see all that. Yeah, cool. All right. Trustees. Who may serve as trustees? Okay. And if you that by accident. Okay, so we're dealing with RCW L.11.36.021. Okay, trustees. Who may serve? The following may serve as trustees: any suitable persons over the age of 18 years, if not otherwise disqualified; any trust company regularly organized under the laws of this state and national banks when authorized to do so. I'm reading this to show you that a trustee can be an entity as well as a natural person. Alright? Who else can be a trustee? Any non-profit corporation. If the articles of incorporation or bylaws of that corporation permit the action, and if the corporation is in compliance with all applicable provisions of Title 24, right? If it's a domestic trust, which you shouldn't be one, you should be a foreign trust, all the way. Okay? Any professional service corporations, professional limited liability companies, or limited liability partnerships. Okay? So this is how it rolls for Washington State over here where I'm doing commerce at. Okay? Trustees can be entities, right? All banks are trustees. Okay? Let's move on to the next documentation. And I got this off of the IRS website. Let you look at the document again. Okay. Trust, Common Law, and IRC 501c3 and 4947 by Ward L. Thomas and Leonard J. Hensk Jr. Okay. I'm letting you see that it's the same thing across the board. Okay. Purpose. The service. Let me see if you can see that. Make that bigger. Should be able to see that pretty good. The service published in a lengthy and sophisticated discussion of trusts with particular detail on split interest trusts in Trust Primer 2001. It's a pretty old document, but the principle has never changed. It's still the same in 2024. That's why I showed you the RCW for Washington State. You can pull up the one for your state in reference to trust, and you can get familiar with how to do your commerce. And it's not so, you're not reading that to put yourself underneath the jurisdiction of the state. You're reading that so you can better understand how to transact commerce with the state, how you're supposed to be treating your property, what's the proper process and protocols on what to do with your property. Should your property be in your name, or should you have already transferred that over to your trust, or aka your trustee, right? Because a trust is what? A trust is a legal relationship in which the owner of property gives it to another person or entity. That is what trust is. Trust is a legal relationship. Trust is not in itself it is not in itself just like a entity or a type of entity. It is a concept. Just like how marriage is a concept. But a trust is no different than a marriage, because a marriage is a legal relationship. When you put it down on documentation and you both agree to sign and etc., it becomes a legal relationship. That's how things are cemented here on the earth plane. They're cemented here on the earth plane through contracts. Okay? That way, if anything happens to you, those contracts can advise those still living on what to do with your assets, or how certain things should go, or what's the procedure or protocol since you're no longer there. But a trust is a legal relationship in which the owner, so that means if I have this car or I have this phone, I was the owner of this phone. Guess who's the owner of this phone now? Cool Breeze. Not Cool L. Cool Breeze is the owner of this phone. Cool Breeze is the owner of this phone, not Cool L. Cool L is the natural person. Cool Breeze is the entity. Owner gives property over to another natural person or an entity, and that relationship forms what is called a trust. And then from there, you give that trust whatever name you want to give it. Okay? Let's go back to documentation here. Okay? This office, however, continues to receive requests from EO examination and determination specialists for basic legal information on trusts. This article will discuss common law and federal tax definitions, distinctions, and rules regarding trusts, with a focus on charitable trusts and IRC 501c3, and some discussion on IRC 4947. 4947 is private foundations. Okay? So, and we're just here to get the basics, okay? We're just here to get the basics. This is why I show you the books, so you can go and find them yourself. Or, I think I'm just going to publish this book up on the Patreon site. That way you guys can have access to it. Okay? So, introduction. Let's get into it. Mind you, what am I reading this document for? It's in reference to trust. You can see what entails across the board. Okay? Kind of organization. Trusts are one of the major forms of organization. Trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units. Those governmental units would be your tribal governmental units. That is what your trust, that is what you're creating the trust for. The trust is the protector of the assets of your tribal governmental unit. Trust instrument, Constitution. Trust instrument is the original contract in which you and your members agreed to take on this particular mission together. Okay? That's what that is. That'll be the deed, the trust, the deed of trust, or the declaration of trust. Then from there, you have the Constitution, not bylaws. Not bylaws. You don't have bylaws for a tribal governmental unit. You'd have a constitution. Because your tribal governmental unit is a state. States have constitutions, not bylaws. Being very clear here, okay? So, trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units. Restatement definition. The restatement of Trust, 1959. Hereafter restatement, subsection 2 defines a trust generally as what? A fiduciary relationship with respect to property, subjecting the person by whom the title to the property is held to equitable duties to deal with the property for the benefit of another person, which arises as a result of a manifestation of an intention to create it. So normally people who, and this is from my own experience, right? Normally people who have the concept to establish a trust are normally people who have their the next generation in mind. They're not thinking about themselves here. They're thinking about those who are come after them. Sons, daughters, your heirs. You're thinking about those who are going to come after you. Those who are going to come after them. You know, you may be thinking about your 10 times great grandchildren and what their experience will be like on the earth plane, and how the things you're doing today is going to benefit them in their time, when it's their time. You know what I'm saying? So normally those are the type of people who will have trust, because a trust is not something for you in the moment. A trust is you're establishing and building and securing wealth for yourself now, but you're also retaining it and establishing it for your future heirs and their children and their children and their children. If you're not thinking like that, you're 9 times out of 10 you're not gonna be thinking about trust or trust law. Okay? Because there's a reason for trust. There's a reason for it. Okay? So boom. Defines a trust. Okay? Regulation 301.7701-4 defines a trust as an arrangement created either by will or inter vivos declaration, whereby trustees take title to property for the purpose of protecting and conserving it for the beneficiaries under the ordinary rules applied in chancery or probate courts. And that's if you are not establishing your trust underneath your own laws outside the states. You should never establish, you should never have the governing laws of your trust established upon the laws of the state. You should have it established upon the ancient laws of your American Indian ancestors or your Moorish ancestors, which means that it's organic. It should come organically, like from scratch. Sure, you can go and look at other laws and take the best parts of it, you know, that you see would best serve yourself and your community, and you put that together, and then you establish that as a new standing law, governing law for your trust. It should be basing nothing on the United States. It should be in harmony with the United States of America, but you should be basing nothing on the United States. Okay. Generally speaking, an arrangement will be treated as a trust under the Internal Revenue Code if it can be shown that the purpose of the arrangement is to vest in trustees responsibility for the protection and conservation of property for beneficiaries who cannot share in the discharge of this responsibility and therefore are not associates in a joint enterprise for the conduct of business for profit. Do you understand what that's saying? So because the trustees are operating for the benefit of the beneficiaries, it's not considered, they're not considered associates in a joint enterprise, okay, for the conduct of business for profit. This is not about profit. This is about preserving, protecting, and acquiring wealth and maintaining that for your heirs. That's what that's about. It's about maintaining an existence of yourself and your likeness. This is what you're doing. The regulations emphasize the non-business character of the activity. Thus, a trust for state law purposes may be treated as a corporation or partnership for federal tax purposes. That's if you're basing it off the state, right? I just want you to see that the laws are the same, right? Who are the parties of a trust? You have what? Your grantor, trustee, beneficiary. Okay? The trustee or trustees receive the property and hold it for the benefit of one or more beneficiaries. The trustee is the legal owner of the property but must use it for the benefit of the beneficiaries. As a fiduciary, he owes the beneficiaries duties of loyalty and care. So imagine if your trustee is an entity. This is what your entity owes you. They are your fiduciary. They are your protector. Right? They're the legal owner of the property that belongs to you, but you gifted it to them so you entrusted it to them, meaning the entity or whoever natural person you're trying to do, or you're trying to establish that relationship with. But 9 times out of 10, if you're starting out by yourself and you don't really have a team, you should make your trustee an entity. That way you can function still as the beneficiary, right? You can function as the grantor and beneficiary, and the trustee being an entity. Okay? So the trustee is the legal owner. You, as a natural person, are the equitable owner. Equitable. Let's look up what equity means. Black's Law Second Dictionary online, right? You can also look this up in any hardcover dictionary too, man. Alright? In its broadest and most general signification, this term denotes the spirit and the habit of fairness, justness, and right dealing, which would regulate the intercourse of men with men. Okay? So, wouldn't you want to be an equitable owner? Because this is what comes with that. The spirit and the habit of fairness, justness, and right dealing, which would regulate the intercourse of men with men. Okay? What is intercourse? Communication. Literally, a running or passing between persons or places. Commerce. As applied to two persons, the word standing alone and without a descriptive or qualifying word does not import sexual connection. Here's the case law for your ass. Here's the case law for your ass. Okay? Look at that. In case anybody want to try to get funny. Right? This is for your knowledge. Knowledge is power. Okay? So what is intercourse when it comes to law? Communication, literally. A running or passing between persons or places. Commerce, as applied to two persons. The word standing alone and without a descriptive or qualifying word like sexual intercourse does not import sexual connection. T-Pole versus Howard, 143 CAL 31676 PAC 1116. Okay, so let's keep it pushing. Back to where we was at. Where were we at? We were just talking about equity. Right. So he's holding it for your benefit. The trustee is the legal owner of the property, but must use it for the benefit of the beneficiaries. Okay? As a fiduciary, he owes the beneficiaries duties of loyalty and care. The trustee may be an individual or organization. Trust companies and banks specialize in acting as trustees in addition to conducting banking and loan businesses. You've experienced this in your own life. Every bank you go to, shit, I have a bank. I have a bank account too. I have a trust bank account. Which is interesting though, right? If you have a trust bank account, because the trust is my entity is my trustee, and then my entity is dealing with what would you call that? A sub-trustee? So the trustee is dealing with a sub-trustee, right? Because the bank is not dealing with me. It's dealing with my trust. So my trust is dealing with the bank, who's a trustee, or who's a sub-trustee for my trustee. So the bank is the trustee for my trust, and my trust is the trustee for me. If that makes sense. Let me say it one more time. The bank is the trustee for my trust, and my trust is the trustee for me as a natural person. The grantor and trustee ordinarily may be the same person and may create the trust by declaring that he holds certain property in trust. The sole trustee and sole beneficiary may not be identical because the purpose of a trust is to separate the legal and equitable interests. Okay? So you put the legal interest into your entity, and then you put the equitable, and you leave the equitable interest into yourself as the natural person. The beneficiary. The beneficiary, also known as the cestui trust, is the beneficial or equitable owner of the property. The beneficiary is said to have the use of the property and can appeal to the court for an accounting or replacement of the trustee to ensure proper use of the property. And if you know how to establish your own trust, you're not going to be needing no courts to do any of that. We all know that, especially if you're formulating your own tribal government. Especially if you are an American Indian, if you are a Moor that belongs here to this landmass. Okay? You are not bound to the laws of the state or bound to the laws of the United States of America. But check it. The beneficiary is also known as the cestui trust. Like cestui QV. This the game that's being played on us, y'all. The cestui trust for us, which would being born domestically in the United States without knowing what the hell was going on, right? That was our cestui trust. The birth certificate is the representation of that cestui trust, in which the United States is the legal United States Corporation Company, or the District of Columbia is the legal owner of all properties. And if you're underneath that jurisdiction, then you are considered as property. And the District of Columbia is the legal owner. Who's the equitable owner? The equitable owners would be the natural persons who are actually running the United States, like private bankers and secret Jewish societies, or the Boule. You know, those type of folks. Okay? Those are the equitable owners. So this is why you must formulate your own trust and pull yourself out of that jurisdiction, so now you can put yourself in the owner's box from an equitable standpoint, because you can't have equity as property. Property can't own property. And this is what you are as a 14th Amendment citizen. Okay? And what is the property considered? What are the parties to a trust? Continue. Property. Alternative names for the property transferred to the trust are the capital, corpus, estate, principal, res. So these are alternative names for the property. So now do you have a better understanding of what your estate is? Your estate is all the property in which you are an equitable owner of. That is your estate. Both corporal and incorporeal. That means things tangible, intangible, things you can touch and things that you can't touch. Okay? So we're done with that portion. Let's get to this now. Just to give you one final overview. Okay. Trust. This I just found on Fine Law, right? Free legal website. I'm just letting you see across the board, it's the same understanding, okay? Trusts are estate planning tools that can replace or supplement wills, as well as help manage property during life. A trust manages the distribution of a person's property by transferring its benefits and obligations to different people or entities, okay? There are many reasons to create a trust, making this property distribution technique a popular choice for many people when creating an estate plan. The basics of trust creation are fairly simple. To create a trust, the property owner, called the trustor, grantor, or settlor, transfers legal ownership to a person or institution called the trustee to manage that property for the benefit of another person called the beneficiary. The trustee often receives compensation for his or her management role. Trusts create a fiduciary relationship running from the trustee to the beneficiary, meaning that the trustee must act solely in the best interest of the beneficiary when dealing with the trust property. Wouldn't you want to put yourself in this type of situation where your entity is obligated to put you in the to have an entity that acts solely in the best interest of you when dealing with your property in which it has legal title to. You have equitable title, that means you have the right to use it, but you don't own it. You've entrusted that to another entity or natural person. That's the game, y'all. That's what we missing. If a trustee does not live up to this duty, then the trustee is legally accountable to the beneficiary for any damage to his or her interests. The grantor may act as the trustee himself or herself and retain ownership instead of transferring the property, but he or she still must act in a fiduciary capacity. A grantor may also name himself or herself as one of the beneficiaries of the trust. In any trust arrangement, however, the trust cannot become effective until the grantor transfers the property to the trustee. Example: a grantor transfers money to a bank as trustee for the grantor's children, with the bank instructed to pay the children's college expenses as needed. The bank carefully manages the money to ensure there are funds available for this purpose. The children do not have control of the funds and cannot use the funds for any other purposes. Trust is happening all around you, and you're missing out because you're not in the game. You're on the sidelines, wondering why. Why is this happening to me? Why can't I get my finances together? Because you don't have you don't have nobody protecting your assets. You haven't put yourself in a situation where your assets are protected. Okay. Now, let's get to here, y'all. And this is the book. Okay? Everybody should have a copy of this book. Because this book is ahead, well, I'm not going to say is, but was ahead of its time when I did put this book out. But I feel like people are beginning to catch up. So now it's kind of out of date now. However, this is one of my best works. Well, not one of mine. This is my best work. And I can always come back to it because the principles don't change. And I made sure to stick close to the principles. I'm just flipping for this page right quick. What was that? That's reversion. And so you will establish a trust relationship by utilizing or establishing an entity. Okay? You do that through the SS4 form. What page you on? What page are you on, dude? Okay, cool. So, first things first. In order to be able to establish a trust, first of all, you're gonna need to create a trustee for yourself. Okay? And so, this is the SS4 form, right? This is an application for employer identification number. Okay? And so, you will use this form. You'll fill this form out. Okay? This form is already pre-filled out, so people know how to fill it out. If things are left blank, there's a reason. Okay? If things are left blank, it is a reason. All right? So, Cool Breeze here. That is the name of the entity I wish to create. Who's the executor, administrator, trustee, or care of? I'm not going to be the trustee. I'm definitely going to be the executor. Cool and L. Mailing location, form mailing location. Boom, boom. Okay. Name of responsible party. Cool and L. Social Security? No, we're not connecting none of our trust to no Social Securities. Okay. Type of entity here. Go with the church or church control organization, or go with other nonprofit organization, or you can go with other, and then you can specify, or you can go right here to Indian tribal government. Okay, I'm showing you the options you can go with. Indian tribal government, you can go with other, right, and then just write in, family trust. You see what I'm saying? And just keep it private. Okay. Reason for applying. Other. W8 Ben purposes only. You can see that. Okay. Reason for applying. Other. W8 Ben purposes only. W8 Ben is for treaty tax exemptions. Okay. So you're doing this for treaty purposes only. That means that when you establish this entity is connected to treaty. You see how I'm operating now? All my entities and structures are connected to a treaty. I don't have to specify on this form what treaty that is, but I do have to specify in my trust instrument what treaty. Okay? And I'm going to show you that. Okay? And then from here, date business started or acquired, whatever, put whatever date, NA, blank, NA, 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 that don't count. Make sure you put yourself here as the owner, put grantor, settlor, trustor, whichever word you feel like utilizing. And if you decide to do it through mail or to fax it, then yes, you must autograph here and date. But if I were you, I would call the IRS over the phone, and I would establish that EIN. The reason why I say that is because you get the EIN at the end of that conversation. And if you pre-fill this form out and have this form in front of you, because the agent that you're going to be on the line with will ask you if you have the form in front of you, because they're going to ask you the same questions on this form here. And you'll just have, all you have to do is just give them what you've already written and just go through the form. Go through the form as you have it filled out. Okay? And like I said, if you don't want to go with church or church control organization, you can choose other nonprofit organization, and you can specify, or you can just put other and just write family trust. Other family trust. Or you can come right here, Indian tribal governments or enterprises. You have options, okay? That's what I'm saying. Now, then you'll need a trust instrument. Okay? So here is my declaration of trust. Okay? And all trusts come underneath the umbrella of Sunel Republic. Right? That's how I set myself up to make sure all my assets are protected. Right? Sunel's the legal owner. Because Sunel's the parent over Kuel Breeze. Kuel Breeze is a subsidiary of Sunel. It's a child. Okay? So Sunel will be considered the parent trustee. Okay? So these are the facts. The Religious Indigenous Unincorporated Association. Now, like I said, this is why I said this is a little bit out of date, but the principle is still the same. So rather than here, right, if you're not going to go with the church or church affiliated, then I would just put the family trust, right? This family trust derives the authority from whoever you are. This is how I title myself, Ku'un El, the Moor, the indigenous being, true heir and descendant of the Moorish Empire. Okay? So that's how I established myself as being the authority for the establishment of this trust. Okay? You don't have to word it how I word it. I'm just letting you know how I'm giving you governmental insight. Okay? Because this is a governmental document. Okay? This is the governmental seals right there. You'll see the other seal on the bottom once we get through this. Okay? So it derives the authority from Ku'un El. Okay? The articles for the unincorporated association, which is another term for trust, is completed for the Ku'un El, the indigenous being, in propria persona, su juris, su heritis, solo proprio, the owner in equity hereafter. Okay, so I'm putting it down in documentation. I'm making it real. Okay, the mailing location of responsible party is Maghrib Al-Aqsa, Morocco, care of, give them a local mailing location. Right, it'll ask you for the date of creation. The owner in equity. Who's the owner in equity? Me. Okay, authorizes under these terms to claim title, to request a certified copy of title, and to transfer title to all property in the name of Kuel Breeze. Okay? So a relationship is established now. Okay? Governing law. The Religious Indigenous Unincorporated Association is governed pursuant to the Treaty of Peace and Friendship between Morocco and the United States of America, signed July 15, 1786, 1836, amendment in harmony with the American Constitution, 1791, specifically Article 6, which is the Supremacy Clause. That's the one that states that treaties are the supreme law of the land, and Article 3, Section 2, which is dealing with the diversity of citizenship. Very specific in how I laid down the governing law. Okay? And once again, Sunel has a constitution. Okay? So this trust is not governed by Washington State. This is governed by Sunel Shi Amaru Republic. Okay? So, jurisdiction. The jurisdiction of the Religious Indigenous Unincorporated Association is within the ancestral Moorish dominions of Maghrib al-Aqsa, and then I use the geographical coordinates. Okay? North America, South America, Central America, modernly today, Washington State. Washington, a state republic. Okay? Mission statement. Cool Breeze is a religious indigenous unincorporated association for indigenous peoples that helps support the missionary work of uplifting fallen humanity by establishing curriculum programs that range from civics, indigenous world history, religion, science, economics, spirituality, and various other ways that help support and sustain Sunelshi Amaru Republic, a governmental organ of the Moorish Empire. You see how the things are set up. Okay, this is all based on imagination and creativity and understanding how you can utilize your resources and plug everything in. Okay, so this is the laws that's governing my trust. This is what governs my trust. Okay. Purpose. The primary objective of the Religious Indigenous Unincorporated Association is to function as an organ of the Moorish Empire and hold legal title to all activities, assets, tangible and intangible, in trust irrevocably, including all indigenous services and businesses of all kinds for all subsidiaries and DBAs doing business as entities and affiliate entities of Cool Breeze. So that if I ever want to establish anything underneath Cool Breeze, then that will also fall underneath the same laws. I don't gotta sit there and keep on writing the same shit for every new trust I establish. You create the umbrella and just let everything sync up with the umbrella. The affidavit of this association, or whichever word you want to put there, right, is incorporated as the authority of this indigenous association. Any other amendments to the affidavit can only be made by Ku'un El, an indigenous being of Moorish descent. And then, you establish what it's pursuant to. Pursuant to the Declaration on the Rights of Indigenous Peoples, enacted by the Organization of American States, which the United States and all its departments are subject to all articles incorporated. Pursuant to the Articles of Confederation, which is the original Constitution for the United States of America. The United States of America is who we have a treaty with, not the United States. Okay? Pursuant to the Treaty of Peace and Friendship, 1786, 1836 Amendment. Also, too, you got to keep in mind around that time period, the United States of America was run by Moors. The founding fathers are all Moors. George Washington is a Moor, Thomas Jefferson is a Moor, Andrew Jackson is a Moor. These are all Moors. Okay, in 1786, because you need to read the letter from Benjamin Franklin. You need to read, the letter of Benjamin Franklin is 1751. I did a video on that. You can probably catch that one on the YouTube. I did a video on Benjamin Franklin's letter, where he's talking about the races and the new people that are coming in, and how the white folks' population is considerably very small. And this is 1751. So you're telling me that their population increased in less than 30 years? With the treaty being signed in 1786? You see what I'm saying? Oh, well, that's more than 30 years. Yeah, a little bit more than 30 years. Doesn't make sense. Doesn't make sense at all. That the people who are representing the United States of America will be the Slavs. Because we all know that the 13 colonies was run by Sephardic Moorish Jews. Not Slavics, not Slovenian people, right? You just got to put the pieces together. All right? Live according to the truth. Pursuant to the Zodiac Constitution, right? It's pursuant to, not the governing law of, but it's pursuant to. Pursuant to the divine constitution and bylaws of the Moorish Science Temple of America. You establish your trust however you wish to establish your trust. But I know I'm making sure that I'm in alignment, okay, to the best of my ability. I, the Ku'un El, am, with the age of the majority, authorize the affidavit with the facts herein. I, the Ku'un El, am with the mental capacity to authorize the official affidavit of facts for the record. I, the Ku'un El, have the personal knowledge of the facts with the affidavit. The articles of organization or declaration of trust, or whichever way you want to name your document, is made under the penalties of the perjury and stands as the authorization of the creation of this religious indigenous unincorporated association as the matter of the law and of the fact. Okay? And then you have your jurat. I, the Ku and El, affirm under the penalty of the perjury, under the laws of the Moorish Empire, being in harmony with the American Constitution, 1791, that the foregoing is true and correct to the best of my knowledge. Reserve my rights. Okay? Got that notarized. See what I'm saying? Preparer, Ku and El, ancestral estate, Maghreb al-Aqsa, Morocco, North, South, Central America. Put man on location. So I authorized this document first, right? With the seal, with the Great Seal of Sunel. And then I brought it over to a notary to make that more perfect union. To make the more perfect union. Perfect is already perfect. Perfect is already perfect. You can't make perfect more. How can you make something more perfect? No, this is the more perfect union between a Moorish state and the United States of America. Okay? And that's how we roll. Alright? So with that being said, family, that's the take on trust. I hope it was thorough. I was trying to be as straight to the point as possible because this topic can be very confusing if you don't have a direct start point and a direct end point. Because you can just go on and on and on and just get lost in a whole loop. But I'm trying to bring you from a start point to the finish line. Okay? And then from there, once you have this document lined up, then you start taking this document with you where you go to start transferring properties over to that trust. Okay? So thank y'all for y'all support. I appreciate y'all. Keep on building the family. I'm gonna keep on dropping new classes, dealing with new topics. All right. Stay well, stay healthy. We'll speak soon.